In today's video, I'm going to talk about the European Convention on Human Rights, short ECHR. The video consists of 4 parts: a short introduction, a few words on the genesis of the European Convention on Human Rights, an overview over the rights entrenched in the Convention, and some information about the interpretation of the ECHR. The European Convention on Human Rights is an international treaty. It contains a catalogue of fundamental rights and freedoms. States which sign the European Convention on Human Rights thereby enter an obligation to secure the rights which are enshrined in the Convention to every person within their jurisdiction. There is a special court which has the task to control that states meet this obligation: the European Court of Human Rights in Strasbourg. People who feel that their rights under the Convention have been violated may take their case to the European Court of Human Rights. Judgments by the court are binding on the states. Through its jurisprudence, the European Court of Human Rights has broadened the scope of the ECHR significantly. Thus, it has developed from an instrument to protect the most fundamental rights into a Bill of Rights for Europe. The European Convention on Human Rights has been signed by 47 states. It applies to more than 820 million people in Europe. Each year, tens of thousands of people submit cases to the European Court of Human Rights. Judgments by the European Court of Human Rights frequently do not just decide the individual case before the court, but have consequences for the justice systems throughout Europe. The system of human rights protection established by the ECHR is unique. There are treaties governing the protection of human rights in other parts of the world too, as well as international courts to ensure that they are respected. An example is the African Charter on Human and People's Rights. Its observance is controlled by the African Court on Human and People's Rights. To many states on the American continent, the Inter-American Convention on Human Rights applies. The Inter-American Court for Human Rights is mandated to ensure that it is respected. However, these treaties and courts do not compare to the European Court of Human Rights in respect to the possibility of individuals to submit cases, in respect to the number of cases decided, and in respect to the impact on national justice systems. The European Convention on Human Rights was created in the aftermath of the Second World War. The experience of National Socialism had shown that the protection of human rights on a purely national level was not always sufficient. Communism and Stalinism were spreading. The ECHR was originally designed as a bulwark against totalitarian systems. While the Second World War was still waging, politicians of the Allies already started thinking about the post-war order. In 1941, American President Roosevelt spoke of the world founded on 4 basic human freedoms: freedom of expression, freedom to worship God in one's own way, freedom from want, and freedom from fear. As early as 1942, Winston Churchill spoke of a time in which the struggles of this world will end with the enthronement of human rights. Therefore, there existed aspirations to entrench human rights in international law after the Second World War. On a global level, this task was taken on by the United Nations. The United Nations established the Human Rights Committee and tasked it to draft an international treaty which was to govern the international protection of human rights. It was supposed to consist of 3 parts: a general declaration as introduction, a catalogue of guaranteed rights, and some rules regarding enforcement. However, political support for this project soon dwindled, among other things, on account of the East-West conflict, which grew stronger. Therefore, the intended document was not drafted and adopted. The Universal Declaration of Human Rights, which had been intended to be the opening chapter of the document, was adopted on 10th of December 1948. It is not a legally binding document. Still, It is considered as a milestone in the international human rights protection. On the European level, there were aspirations to adopt a document regarding the protection of human rights too. They form part of attempts to strengthen cooperation between European states or even to create a unified Europe. In 1948, a congress took place in The Hague, in which many organizations took part which advocated for a unified Europe. The opening speech was delivered by Winston Churchill. In that speech, he advocated the creation of a European Charter on Human Rights. Following the Congress, many of the organizations which had participated gathered under a common roof organization. The European Movement was born. The European Movement drafted the text for a European Convention for the Protection of Human Rights. Important parts of this draft are contained in the European Convention on Human Rights as we know it today. Another consequence of the Congress was the creation of the Council of Europe. The Council of Europe is an international organization which provides a platform for the discussion of issues which are relevant to all of Europe. When it was created in 1949, it had 10 member states. The European Movement sent its draft for the European Convention on Human Rights to the Council of Europe. The Council of Europe picked up the ball and drove forward the preparatory work for the European Convention on Human Rights. Key figures of the drafting process were David Maxwell Fyfe and Pierre-Henri Tégin. Maxwell Fyfe was a British lawyer and conservative politician. He had worked as a prosecutor in the Nuremberg trials against war criminals. Pierre-Henri Tégin was a French professor of law and politician. There were different views as to what rights the Convention should enshrine and to what detail these rights should be formulated. For example, it was disputed whether the right to property, the right to family life, or the right to education should be included in the Convention. It was also disputed whether there should be a court to control the observance of the Convention and which competences this court should have. The European Convention on Human Rights, which was finally adopted, is therefore the result of a political compromise. In some cases, rights on which the participants could not agree right away were added to the Convention later on in form of so-called additional protocols. The European Convention on Human Rights was signed on 4th November 1950 in Rome. It entered into force in 1953. The ECHR consists of 3 parts. The first part contains a catalogue of rights. Contracting states are obliged to secure those rights to everyone within their jurisdiction. I am going to give an overview over these rights later on in the video. The second part of the Convention is concerned with the European Court of Human Rights. It sets out the structure of the court and the procedure before it. These articles are complemented by the Rules of Court, which contain more detailed rules. The Rules of Court are adopted by the judges of the European Court of Human Rights and occasionally updated. The third part of the European Convention on Human Rights has the title Miscellaneous Provisions. The rights which the ECHR is supposed to guarantee are set out in the first part of the Convention. Article 1 of the Convention does not deal with a specific right. It sets out the obligation of states to secure the rights and freedoms entrenched in the Convention to all persons within their jurisdiction. In practice, this article is mainly important for the reason that it states where the Convention is applicable. States are bound by the ECHR within their jurisdiction. That is mainly important for the questions if and to what extent states are bound by the Convention when acting outside of their own territory, for example, when carrying out military operations abroad. The Articles 2 to 14 of the ECHR enumerate the Convention rights as such. Articles 2 to 5 contain rights which are closely related to the physical integrity of persons. Article 2 enshrines the right to life. Article 3 prohibits torture, inhuman and degrading treatment and punishment. Article 4 prohibits slavery and forced labor, and Article 5 guarantees freedom. Articles 6 and 7 are related to trials and justice. They concern the right to a fair trial and the principle no punishment without law, which is set out in Article 7. The following articles concern social relationships, autonomy and communication. Article 8 guarantees the right to respect for private life, family life, home and correspondence. Article 9 guarantees freedom of religion and conscience. Article 10 freedom of expression. Article 11 freedom of assembly. And Article 12 the right to marry. Finally, Article 13 that sets out the right to an effective legal remedy, and Article 14 prohibits discrimination. Of course, that is only one way of categorizing the rights enshrined in the ECHR. There are also other ways to systematize them. The rights entrenched in the Convention are complemented by so-called additional protocols. As I mentioned in the beginning, the ECHR is the result of a political compromise. It contains those rights which the contracting states could agree on when the Convention was drafted. However, awareness of the scope of human rights evolves. Thus, the contracting states could agree on additional rights in the course of time. Those were then added to the Convention in the form of additional protocols. Examples are the right to property, the right to education, the right to free and fair elections, or freedom of double punishments. These rights and others were added to the Convention in the course of time. In some cases, not all of the contracting states were ready to guarantee certain rights. In these cases, they did not sign the additional protocol setting out those rights. As a consequence, these protocols are not binding on the states in question. People within their jurisdiction cannot rely on those rights before the ECHR. For example, Switzerland did not sign the protocol guaranteeing the right to property. In addition to that, there are additional protocols which provide for changes to the proceedings before the ECHR. Sometimes that is necessary to deal with new circumstances. For example, it became clear some years ago that the European Court of Human Rights was not able anymore to handle the immense number of applications. Therefore, Protocol 14 to the ECHR introduced the possibility to declare applications inadmissible by decision of a single judge. That enables handling a larger number of cases. An additional protocol will enter into force soon, which foresees that the time limit for submitting applications will be shortened to 4 months. Some rights that are entrenched in ECHR may be limited. Examples include the right to respect for private life, freedom of expression and freedom of assembly. The ECHR provides under which circumstances and to what extent limitations are permissible. In general, limitations require a basis in national law. They must serve a legitimate aim and be necessary in a democratic society. For example, provisions of criminal law prohibiting insults are restrictions of the freedom of expression. The person insulting somebody is punished for a statement. However, this limitation is in principle permissible. There is a legal basis prohibiting insults. This provision serves a legitimate aim, namely the protection of the honor of others. Whether a delimitation is necessary in a democratic society in a specific case is a matter of weighing the circumstances of an individual case. Some rights which are enshrined in the Convention must not be limited. Important examples include the prohibition of torture pursuant to Article 3 ECHR, or the principle no punishment without law set out in Article 7 of the ECHR. Rights which may be limited at any time. There are no specific circumstances required to limit them. For example, insult is always a punishable act. But in addition to that, the Convention provides that certain rights may be limited in special situations. This is set out in Article 15 ECHR. According to that article, contracting states may derogate the Convention in case of war or public emergency. The state intending to derogate from rights informs the Council of Europe. When doing so, it has to set out the reasons for the derogation. However, the derogation can still be reviewed. Even after a derogation, applicants may still take their case to the European Court of Human Rights. The court will then examine whether the derogation was necessary. If it concludes that this was not the case, it will examine the application as in any other case. An example from recent times is the derogation by Turkey following the attempted coup in July 2016. After that attempt, the Turkish government declared a state of emergency and derogated from the convention. The European Court of Human Rights has dealt with the question to what extent this derogation was justified in a number of cases after that. Certain rights must not be limited even in a state of war or public emergency. These are in particular Article 3, the prohibition of torture, Article 4, the prohibition of slavery and forced labor, and Article 7, which enshrines the principle no punishment without law. As mentioned before, I will now give a short overview over the specific rights which are entrenched in the Convention. The first one is the right to life, which is provided for in Article 2 of the European Convention on Human Rights. The European Court of Human Rights has stressed numerous times that the right to life is the precondition of all other rights. If my life is taken, I cannot exercise my freedom of expression anymore. Still, the right to life is not guaranteed without limitations. The wording of Article 2 still allows for the death penalty. That does not play any role in practice though, because there's an additional protocol to the ECHR banning capital punishment, which all contracting states of the ECHR have ratified. Article 2 ECHR has a procedural aspect and a substantive aspect. The substantive aspect means that states have to refrain from illegally killing someone. The procedural aspect means that states are obliged to conduct an effective investigation if there is a suspicion that the right to life was violated. Article 3 ECHR is often referred to as a prohibition of torture. However, the provision goes further than that. It prohibits torture, inhuman or degrading treatment or punishment. The threshold of torture is higher than that of inhuman or degrading treatment. That means a treatment which does not constitute torture yet may still be inhuman or degrading treatment. Regarding the definition of torture, the European Court of Human Rights frequently refers to the UN Convention Against Torture. Article 3 ECHR is one of the provisions which must not be limited and cannot be derogated from either. Thus, torture must, for example, not be used to save other people's lives. The European Court of Human Rights states that it is a consequence of the philosophical background of the prohibition of torture that the prohibition does not permit any exceptions. As Article 2 ECHR, Article 3 ECHR has a substantive and a procedural aspect. The procedural aspect says that states are obliged to conduct an effective investigation if there is a suspicion that the prohibition of torture was violated. Article 4 ECHR sets out the prohibition of slavery and forced labor. The provision states expressly that military service, work in prisons, or civic obligations are not considered forced labor. To date, Article 4 did not play a large role in the court's jurisprudence. However, in the meantime, there are a number of cases in which the European Court of Human Rights examined the state's obligation to prevent human trafficking or forced prostitution. Article 5 sets out the right to freedom and security. The article contains a catalogue of cases in which deprivation of liberty is permitted. The most important examples are prison sentences following a criminal conviction or pre-trial detention. Deprivations of liberty which do not fall under one of the exceptions set out in Article 5 ECHR are unlawful. It is an important element of Article 5 ECHR that the deprivations of liberty may be reviewed by a judge. There is a large body of jurisprudence in that regard in particular pertaining to pre-trial detention. Article 6 ECHR governs the right to a fair trial. Article 6 is only applicable to proceedings which concern civil rights and obligations or criminal charges. That means that there are proceedings which do not have to satisfy the requirements of Article 6. This applies, for example, to certain disputes regarding taxes or administrative proceedings. However, the court interprets the terms civil rights and criminal charge autonomously. That means that proceedings which are not considered civil proceedings under national law or charges which are not considered criminal in the eyes of the domestic courts may still be civil proceedings or criminal proceedings in the eyes of the European Court of Human Rights. Article 6 ECHR contains certain provisions which apply to civil proceedings as well as to criminal proceedings. For example, the right to a fair and impartial tribunal. In addition to that, there are certain guarantees which only apply in criminal matters. Article 6 also sets out the presumption of innocence. Article 7 ECHR enshrines the principle no punishment without law. It states that persons can only be punished for a certain conduct if it was clear at the time of this conduct that it constituted an offense. Therefore, the European Court of Human Rights, from this article, the principle that laws have to be sufficiently clear. It must be foreseeable which conduct could entail punishment. The provision also makes clear that it does not exclude the punishment of acts which were criminal according to the principles recognized by civilized nations at the time they were committed. After the Second World War, many suspected war criminals were put on trial in Tokyo and Nuremberg. Many of them were prosecuted for conduct which were clearly horrible crimes, but which did not always meet the requirements of written provision of criminal law. The wording of Article 7 was supposed to make clear that the article did not put an obstacle to conviction for these crimes. Article 8 ECHR governs the right to private life, family, home and correspondence. These rights may be interfered with subject to certain conditions. Article 9 ECHR sets forth freedom of religion and conscience. They can be interfered with too. This requires frequently a balancing exercise with other rights. Article 10 ECHR enshrines freedom of expression. Freedom of the press and media in general is covered by this article too. The European Court of Human Rights has frequently underlined the great importance of freedom of expression in a democratic society. Article 10 ECHR has also to be considered in disputes between private individuals. In principle, the rights enshrined in the ECHR are rights against the state. However, the European Court of Human Rights has decided that the values or considerations enshrined in Article 10 ECHR must also be taken into account when, for example, private citizens litigate against journalists. In that context, freedom of expression as well as the right to private life pursuant to Article 8 ECHR have to be taken into account. These rights have to be balanced against each other. Article 11 governs freedom of assembly. This right may be limited to: the right to freedom of assembly is a core right for every democracy. It frequently overlaps with the right to freedom of expression pursuant to Article 10 ECHR. Article 12 sets forth the right to marry. Article 13 guarantees the right to an effective legal remedy. That means that individuals must have a possibility to redress the violation of their rights which they enjoy pursuant to the ECHR. Of course, effective does not mean that they have to be successful. In other words, a legal remedy is not to be considered ineffective just because the person in question lost the lawsuit. The question of an effective legal remedy also plays a role in regard to the admissibility of applications to the ECHR. Applicants have to exhaust all domestic legal remedies before taking a case to the ECHR. However, this only applies to effective remedies. Article 14 ECHR prohibits discrimination. Discrimination means that two groups of persons which are in comparable situations are treated in an unequal manner without a legitimate reason. What is important is that Article 14 does not prohibit discrimination in general. Rather, discrimination is only prohibited in regard to the enjoyment of another right guaranteed by the ECHR. Consequently, Article 14 ECHR is only applicable in connection with another article of the ECHR. A general prohibition of discrimination is contained in Additional Protocol number 12 to the ECHR. However, only a few states have ratified that protocol. Fundamental rights are supposed to be applicable in a large number of different situations and for a long period of time. For that reason, they must be worded in a rather broad manner. Due to this broadness, it is of great importance how those provisions are interpreted. The ECHR forms part of international public law. Therefore, the Vienna Convention on the Law of Treaties applies to it. However, patterns or models of interpretation developed by the European Court of Human Rights itself are more important in regard to the interpretation of the ECHR. An important principle is that the European Court of Human Rights considers the ECHR as a living instrument. That means that the Convention does not have to be interpreted to mean what it meant when it was drafted. The Court assumes that the understanding of certain rights evolves over time and that the interpretation of the ECHR has to evolve with them. For example, the European Court of Human Rights is of the opinion that the right to family life pursuant to Article 8 ECHR applies to homosexual relationships, even though probably nobody thought of that when the Convention was adopted in 1950. Closely related to this idea is the concept that the ECHR has to be practical and effective. In the Court's point of view, it has to be interpreted in such a fashion that citizens can actually enjoy the rights enshrined in the Convention. Another important idea is that of the autonomous interpretation of the Convention. It means that the European Court of Human Rights does not consider itself bound by the interpretation of legal terms or notions by domestic courts. For example, Article 6 ECHR grants certain rights to persons faced with a criminal charge. What is considered a criminal charge is not determined by whether an accusation is considered a criminal charge in a certain member state. The European Court of Human Rights assesses that on its own. A procedure which is considered a disciplinary procedure pursuant to the right of a member state can still be a criminal procedure in the eyes of the European Court of Human Rights. Finally, it is important that the European Court of Human Rights assumes that states enjoy a margin of appreciation. That means that states have a certain discretion or room to maneuver when it comes to putting the Convention into practice. The Court only reviews whether states have overstepped the margin of appreciation.